Docket. Case number 107776, Whaley v. Sharp.
Good morning, Your Honor. I'm Lynn Johnson. I'm here representing Janet Whaley, the plaintiff and appellant in this case. And we are asking that, based upon the plain language rule that this court has been discussing in many opinions over the past several years, that it hold that KSA 12-105BD does not require compliance with its requirements as a prerequisite to filing a cause of action against defendant Sharp, in this particular case, a former employee of a municipality. And we respectfully request that this court reverse the Court of Appeals and, of course, the district court's decision and send this matter back for adjudication on the merits.
Counsel, the thing that's been bothering me with this is the vicarious liability element that's dangling. Do we really even need to get involved with that?
No.
Because we can just look at the plain language of the statute and be done.
That was an alternative that we proposed to the district court and to the Court of Appeals because obviously if this court rules that the plain and unambiguous language does not require compliance with this notice of claim statute, it will have to overrule the King case and the Norp case from the Court of Appeals. And so, given the fact that there were Court of Appeals decision, we felt that we needed to pursue that. But in our opinion, this is a very clear matter and does not require that analysis.
One other question. It would be conceded that if employees aren't covered by the statute, then they would not benefit from the tolling provision that's in there. So, I mean, we have to accept the notion that there'll be those times when separate lawsuits have to be filed and then that has to get sorted out later. We always see these cases when it's right on the edge of the statute of limitations. And so plaintiffs are going to have to, even if they want to make a claim against the municipality, recognize that the employee liability portion is going to have to be filed within the 2 years.
Yes, Your Honor, and I think basically if the court rules as we are urging the court to rule, that would be a determination from that point forward. In other words, I don't think anyone's going to be caught in a trap, so to speak. I'm not sure that was your question, but if there are currently pending cases where someone may have followed the King rule, I think this court can make that clear in its opinion that this applies, the statutory interpretation overrules King and applies from this point forward, applies to this case and to cases forward. If your question is, how will it really be handled, I think any attorney who is looking at a case like this where there's liability of an employee or a former employee will have to make the decision on how he or she handles a notice of claim. If that attorney wants to hold the municipality responsible for the acts of its employee, then of course a notice should be given. If, on the other hand, such as in this case, where the defendant Sharp has adequate insurance and has viable means to satisfy a judgment on his own, then the attorney may just choose to pursue by filing a case against the employee or former employee. I won't go over the history. I think the court probably knows it well. I would point out that recently this court in the case of Sleeth versus Sedan City Hospital, written by Justice Biles, noted that even though it was looking at 12-105BD, this court had not been asked to determine whether it applied to employees or not. I think at that time this court had granted our motion or our petition, and perhaps it was in reference to the fact that this case would be coming forward. So we would add that case. And then there's also another case that I'm very familiar with, Fisher versus D. Carvalho, which is 298 Can 842, where I think Justice Johnson wrote the opinion that determined that the Grimmett factors were not applicable to 60-203B, so that would be another case where this court has looked at the plain language of a statute and has overruled a Court of Appeals decision that applied. Your Honor, I forgot. I want 10 minutes to rebut. Am I too late?
No, our rule says as long as you ask for the time during the hearing, and this is the hearing.
Good.
Good.
I jumped right into a question and didn't do that. I'm sorry. In the Fisher versus D. Carvalho case, Justice Johnson, again citing the long soliloquy of cases ever since Bergstrom, and determined that the Grimmett factors had been added on. I would say similarly, this is the King factor that is added on to the notice of claim and should not be part of the interpretation.
Mr. Johnson?
Yes.
You mentioned that we would be free in an opinion to say that this is a merely forward-looking rule as opposed to having retroactive application on anything else that had already been filed. I'm a little troubled by that. We don't normally do that with statutory interpretation. We usually do it in, well, not even usually, it's a rare thing to do, period.
Right.
But we have done it certainly when substantive rights are affected, particular constitutional issues. That slowed me down there.
Well, maybe I was too glib with that point. I guess my point is that if someone right now has complied with 12-105BD, and they're waiting for the 120 days to go by and the statute of limitations expires, I just don't believe that if this court finds, as I hope that it does, that that could be used against that plaintiff in that case, given the fact that that plaintiff and that plaintiff's attorney was relying upon King.
As was relying upon the statute as interpreted at the time, is what you
Right.
mean. Which I understand that. I think it probably ends up coming down to a vested rights kind of analysis rather than a.
Right.
Yeah. Okay. And it's not this case, but that slowed me down.
Yeah, I may have. I think the point is that's not. I think it's raised by the Court of Appeals and perhaps by the defendant. I don't think that's an issue that should stop this court from using the plain language rule to interpret the statute. In addition to the Sleeth case that I mentioned, the Fisher case, there have been two other cases that have been decided that I think are of interest. One is the O'Brien versus Ligon Creative Leather Products case, 294 Kansas 318, written by Justice Beyer, and the Fernandez versus McDonald's case, 296 Kansas 472, 2013 case written by Justice Johnson. Again, those two cases simply reiterate the principle that since Bergstrom in 2009, this court has determined that it is not up to us to add something to a statute not readily found in it. And in this particular statute, it starts right off by stating, in any claim against a municipality, not a municipality and its employer. I think it was interesting in the O'Brien case that Justice Beyer kind of put a public policy note by saying that we will not speculate, that by stating that the legislature is presumed to have expressed its intent, but more importantly, we take the legislature at its word, unless there's ambiguity, because the legislature, unlike the judiciary, is one of the branches of government charged with development of public policy on behalf of the electorate, and because our deference to clear statutory language leads to long-term predictability. In other words, this court doesn't set public policy. This court has to defer to the language of the legislative body that does establish public policy. Judge Johnson, excuse me, in the Fernandez case, also picked up on that, and I think it's a good point. The legislature establishes public policy. This court must give deference to the legislature and interpret the statutes under the plain language rule. Unless there are any questions, I'll wait for my rebuttal. Thank you.
Any questions of council? Thank you.
May it please the court. This is a Kansas Tort Claims Act action. Kansas Tort Claims Act actions involve not only municipal entities, but also their employees, and also their former employees of the municipality. So it's undisputed this is a Kansas Tort Claims Act action. The issue, if we condense both issues into one, is does plaintiff have to comply with the notice provisions of KSA 12105B before commencing any Kansas Tort Claims Act action? And the answer is yes. In fact, we know that they did file a 12105B action or notice in this case. The language of the statute includes this. It says, once notice of the claim is filed, no action shall be commenced until after the claimant has received notice from the municipality that it has denied the claim, or until 120 days has passed following the filing of the notice of claim, whichever occurs first. And so the district court and the Court of Appeals read the phrase no action to mean just that, no action.
Would that include a joint tortfeasor that was not an employee of the municipality?
No, I think if we had some third party that was an employee of the municipality, it wouldn't cover that.
How does the plain language no action, which you've said is no action, I mean, how do you accept that out?
Well, my position is the statute's ambiguous. I mean, we do have instances of the word municipalities. We have the instance of the phrase no action, and we also have the phrase at the last of it. This is the tolling provision at the very end of 12105B. It says any action brought pursuant to the Kansas Tort Claims Act shall be commenced within the time period, et cetera, et cetera, et cetera. So it says any action pursuant to the Kansas Tort Claims Act. So Justice Johnson, in response to your question, I think when we get finished doing the analysis of the ambiguity and resolving the ambiguity, I think a fair reading of the statute is we're talking about no action under the Kansas Tort Claims Act or any action under the Kansas Tort Claims Act.
How do you refer to the language in A and D, which says in A, all claims against a municipality, and then D, any person having a claim against a municipality, and then municipality is defined as, and it does not include an employee or former employee. How does that fit into your analytical calculus?
Well, I still contend that the statute is ambiguous. It's got two instances of, the any action and no action. We look at the headings of the statute occasionally in the course of statutory interpretation, and the heading of KSA 12105B says uniform procedure for payment of claims, presentment of claims, and then, quote, claims which could give rise to action under Kansas Tort Claims Act. It doesn't say claims which could give rise to actions against municipalities under the Kansas Tort Claims Act. In fact, we commonly refer to this as the Kansas Tort Claims Act notice provision. In answer to your question, though, what do we do about the first sentence of KSA 12105BD? The first sentence of KSA 12105BD says any person having a claim against a municipality which could give rise to an action brought under the Kansas Tort Claims Act. Well, first of all, there's no rule that says we just go with whatever occurs first in the statute and that trumps everything else. We have to read the statute as a whole. Secondly, the word claim is also defined in the statute. And a claim means this. It's in 12105AC. It says, means the document relating to and stating an amount owing to the claimant by a municipality for some action taken by or for the municipality and for which the municipality may or may not be responsible in a liquidated or an unliquidated sum. And so it's a very low threshold of what constitutes a claim, and it's the document that they present. In this case, it's undisputed that they presented a claim against the municipality. And so I guess I would say two things. First of all, you have to resolve that, first of all, the statute's ambiguous. Secondly, even if we took the first sentence of KSA 12105B and read it by itself and stopped there, plaintiff did present a notice of a claim for which the municipality may or may not be responsible. Then when we get to the sentence number 5, I believe it says once you do that, then no action can be filed. Not no action against the municipality.
So, to borrow some words that were used by one of my colleagues on a case earlier this week, if the claimant in this case or plaintiff submitted a claim under the Tort Claims Act strictly as a prophylactic because that person was not sure how this court would rule and they decided to be safe, in your view, that has the effect of a binding admission, or they are stopped from making any kind of an argument? I'm a little unclear as to what your position is.
Well, first of all, there is a bit of a false dilemma in the argument.
In whose argument?
In plaintiff's argument about, in their briefs, it didn't come up so much in the argument today, but it's triggered by your question. They're not really put in a dilemma of choosing whether or not they're going to file the claim or not. They can file a notice of claim if they feel that one may be necessary. If they're up on the statute of limitations, they can file their lawsuit. They can do both. They can wait the 180 days or 120 days, plus, and then somewhere in that window of the 90 days, file another lawsuit. So, and then there's another option which I've seen where they dismiss the lawsuit and then within the 6-month saving provision they refile so that it falls within that window. Then one way or the other, they've got a case that has jurisdiction, subject matter jurisdiction, or it's not barred by the statute of limitations. Does that respond to your question?
It seems like a lot of work when it would be easier perhaps for the plaintiff just to say, I'm going to play it safe, here's my notice of claim, whether it is actually required or not. But
Sure,
you've answered
but
my question.
and there's an unpublished opinion from the Court of Appeals that came out this year where someone did exactly that. They did both. The first filing of the case constituted, or the first filing was dismissed on the basis of the idea that the court did not have jurisdiction of the case, following the Sleeth case and several others. And then the second case is still pending.
All right, thank you.
Okay.
Just
So-
so I'm, Counsel, just so I'm clear, you're finding the ambiguity in sub D, the part that says once notice of the claim is filed. I think I've got that. Where's the other ambiguity that you say throws questions into this whole
Let me just
statutory
go through a complete list of where I see the ambiguities, what I would italicize for my argument in the statute. First of all, let's just start at the top. The heading of the statute says claims which could give rise to an action under the...
Before we get into that, there is case law from this court that basically says the statutory headings are not from the legislature, but they're created by the reviser of statutes, and it has little if any...
Concede that.
I'm sorry?
I concede that.
You're just providing it to us for whatever value.
For
it might
whatever
have.
value you find that it's worth, I'm just pointing out, hey, let's note that the heading doesn't say actions against municipalities.
I understand.
Okay. The fourth sentence says, once notice of the claim is filed, no action shall be commenced until after the claimant has received notice from the municipality, etc. That sentence. Then, when you compare that sentence to the sixth sentence, which says, no person may initiate an action against a municipality unless the claim is denied or in whole or in part, one goes, why did they say two different things? If the first sentence meant just municipality, why would the legislature need to tell us twice that you can't initiate an action unless you've received a denial of the notice of claim? So in other words, those two sentences can't mean the same thing, otherwise the legislature is repeating itself. And then finally, the last sentence of the statute, which is the tolling provision, says any action brought pursuant to the Kansas Tort Claims Act shall be commenced within the time period, etc. And so it's not limited to municipalities. So you could say, well, look, why does the legislature use this word municipality all the time? They don't ever use anything else. They don't ever say employees. And my position is they don't need to, because any action and no action are as broad as they could be. Quoting something that Mr. Johnson said.
Let me ask this, Counsel, now that I know the universe of our ambiguity.
Sure.
What is it that makes you think those ambiguities require us to conclude that a notice has to be given to the municipality for a claim against an employee?
Well,
very clearly, the first sentence of D says that it's the claim against a municipality which shall require the filing of the written notice. I mean, I understand, I see what you're saying, and I'm not saying I agree with it, but I understand what you're going. But how does that compel a conclusion that employees get sucked into the provisions of the statute?
well, I don't want to make another pitch regarding my first sentence. I'll run out of time. But I do believe that you can read that first sentence when you look at the definition of claim to mean that even if you're suing an employee, that implicates the municipality. The new point I
Even
want
in a case like this where the municipalities got immunity from vicarious liability?
Boy, that gets into the second.
I know it does, but-
issue that he's conceding that he's dropping.
He didn't say that. He just said you don't have to do it.
Okay, well, I got some more work
But
to do.
I mean, he's just saying this is a simple, plain language case.
Yeah.
So you can stop after you look at the plain language. You don't have to get into the rest of this.
Okay,
So the argument you're making here isn't applicable to the specific facts of this case, because the municipality is not liable.
okay. Let's
For
assume.
this guy.
I disagree that the question of whether the municipality is or isn't liable is a settled question, as we've argued in the brief. I think they're asking you to make a determination of a hypothetical question. Could the Schamberg-Johnson firm, on behalf of the Cryers, sue the municipality for vicarious liability of the physician? That's a hypothetical question that they want you to answer for them as a premise of their second line argument. Why would you give notice to a municipality? Is your question, why would you give notice to the municipality if you're only going to sue the employee? And that
I don't really care about why, because I think that's where we get into public policy thing. I mean, I'm not saying that the statute isn't going to be amended the end of January next year. But we have the statute that we have. My question is, given the ambiguities that you're articulating, why do those ambiguities compel a conclusion that municipal employees are included now in the statute? I mean, that's the second
Sure.
step of statutory interpretation.
Exactly.
Once we get past ambiguity.
Exactly.
So why does it compel? That's all I'm asking.
Okay, yeah, I appreciate it. Well, the fortunate thing is that the King versus Pimentel case did exactly that type of analysis. They said that it was subject to a strict interpretation, a broad interpretation. Then they referenced it in connection with, the purposes sought to be achieved by the statute, the consequences or the effect of the statute if it was interpreted one way or the other. Both the Bergstrom case that was cited and the Fisher case says that if you have an ambiguous statute, you get to consider the consequences of the various interpretations. And if you look at the King versus Pimentel case, they articulate 5 reasons why if there's an ambiguity, it should be resolved in favor of interpreting it broadly to include all Kansas Tort Claims Action claims.
I can't recall, I don't mean to dominate this or cut you off, but I don't
Sure.
recall any legislative history being provided to us But am I wrong on that?
There's been no legislative history provided to you. Okay. And of course, those 5 reasons are in the brief. There's quickly stated, they're the indemnity provision, there's the duty to pay attorney fees. There could be an indemnity action even after the lawsuit is over if you sue an individual employee. That individual employee could have a judgment against them, and then they could seek indemnity from the municipality, and they're going to go, hey, wait, I never got my notice of claim prior to this. So there's risk to them. There's also the benefit that the municipality gets by doing an investigation. And those investigations involve talking to their employees. So the employee gains the benefit. Now, your question earlier implied that what we do, potentially may do, is look at these on a case-by-case basis and determine, hey, was notice necessary for this particular individual at this time? And I think that that's where we get into doing something that Mr. Bergman is saying that the court can't do. We can't make this a case-by-case determination, one case at a time, as to whether or not there's a sufficient justification or reason under those rationales under the King case for giving a notice. Otherwise, we're going to be flooded with a lot of cases on both sides of the issue, both the issue on the statute of limitations issue / tolling issue versus the subject matter jurisdiction issue. I want to talk about the Fisher and the Bergstrom cases. These are the cases that I found, and of course, Plaintiffs' Counsel found that were ones where the court has overturned a Court of Appeals decision that was decided some time ago regarding statutory interpretation. In the Fisher case, decided by the court, but written by Justice Johnson, involved the interpretation of KSA 6203B, which said, quote, if service of process or first publication purports to have been made but is later adjudicated to have been invalid due to any irregularity in form or procedure or any defect in making service, the action shall nevertheless be deemed to accrued, etc. In 1995, the Court of Appeals in Grimlett, without tying it to any language in the statute, just divined and judicially created this long 3-part test for determining whether or not you get to do a do-over on your service. That wasn't found anywhere in the language of the statute, and that was the problem. They divined this long 3-part test that wasn't found in any language of the statute. They said that the phrase invalid, been adjudicated to have been invalid due to any irregularity in form or procedure or any defect meant just that, any form, any defect. And so they couldn't limit it there. So if anything, I think that the Fisher case supports my position that the phrases any action and no action are broad, number one. And number two, that this case is distinguishable from Fisher because the King case didn't divine some new test. They just decided between 2 conflicting interpretations of KSA 12105B, one of which relied upon the phrases no action and any action under the Kansas Tort Claims Act. Bergstrom versus Spears is the same thing. This one was decided by Justice Rosen. It's a workers' comp statute that's being interpreted. It's one on how to calculate disability benefits. And the bottom line is the Court of Appeals back in 1995, without finding any ambiguity or any conflicting interpretations, found that there was a good faith effort to find and accept alternate employment. Not found anywhere in the statute. They said, well, that's implied, otherwise it wouldn't be fair. Again, distinguishable, because they were not starting with an ambiguous statute.
Counsel, what other states' laws were the Kansas Tort Claims Act modeled after?
Your Honor, I may have looked at the answer to that question at one point, but not recent enough that I can answer that.
Was there any effort made to look at that issue and see what those states' appellate courts have done with similar language?
Clear back at the time of the district court, the time that I filed the motion for summary judgment, we did look for out-of-state authority to see if we could find something on point, and we couldn't find anything.
All right, thank you.
I do want to talk, since the second issue, I guess, is still alive, the plaintiff is asking if we should make an exception for plaintiff here due to KSA 12105B because Ashland could allegedly not be vicariously liable for the conduct of Dr. Sharp. That's a complete 180-degree turn from the position that they took in their notice of claim where they said he was vicariously liable. Like the courts below, that you should refuse to issue an advisory opinion on whether or not Ashland would be vicariously liable for Dr. Sharp's conduct or not. If you look at my brief on that point, I'll point out that there's a conflict between KSA 40-3403H and KSA 65-442B about whether when a physician is employed by a hospital, there is vicarious liability or not. Those statutes, if you put them side by side, say two different things. The notice provisions must be followed even if the employer is not sued for vicarious liability. Vicarious liability, even if we assume there wasn't any, isn't the only reason for the notice of claim. We've got those other reasons identified in the King case. And probably most importantly is that on the second issue, plaintiff is asking the court to create a statutory exception to giving notice if there's not a reason to, i.e., if there's no vicarious liability. They're asking the court to pull a Grimlett, for lack of a better term. They want the court to do what the Court of Appeals did in the Grimlett case, which was overturned in Fisher, by coming up with a new test that's not supported by the language of the statute just because they believe that it makes sense. So what are the effects? If I'm out of time, I'll stop.
We'll allow you to continue.
Okay, let me just give a quick kind of summary. If notice is required for claims against municipal entities but not claims against their employers, it'll change the way we've been doing things for the last 20 years. It'll give rise to a new possible pitfall for some plaintiffs who try to get their cases on file or who try to get their notices of claim on file but then find out that maybe they would be barred by the statute of limitations. And that applies not only to past cases, for which the court's going to have to decide whether it has jurisdiction, but also the future cases. It'll require sorting out about which claims were in reliance upon the King decision and which weren't. Litigation begins immediately for employees of the municipality, and the municipality is going to be wrapped into that during their notice of claim period. If litigation begins for the municipal employees, discovery is going to start in that case. Then the municipality is going to be added later to the case, and some of the discovery may need to be done over again. If notice of claim is required for municipal entities, but not some employee, or for some employees but not other employees, because we define a new test that says, well, yeah, most employees are covered, but not ones for which there's no vicarious liability to the hospital or the fire department or whatever, then we're going to have all of those same problems that I talked about for those particular cases. And we're also going to have some difficulty in applying that test. I mean, what is the test going to be? Exclude notice for employees who have insurance, exclude ones that have, for doctors who are insured by the fund, exclude notice where there allegedly couldn't be vicarious liability. Whatever test it is, go back to the plaintiff's lawyer sitting in their office. They haven't even made a demand against the municipality yet. And the question is, should they file a notice of claim or not? Those could be incredibly fact-driven, and it would make the rule very, very difficult to follow for anyone on either side of the issue. I thank you for your time. I just ask the court to affirm the District Court, Court of Appeals, and continue with the King decision.
Before you sit down, counsel, let me ask, if we decide at conference that it would be very helpful for us to have you and opposing counsel provide a supplemental briefing after you've looked at other states and their Tort Claims Act and the federal government's Tort Claims Act, how long would it take you to get us a brief?
45 days?
45 days
Is
for
that too
supplemental
long?
briefing? I was thinking sometime next week.
Oh, next week. I'm getting on a plane and going to New York. I won't be back till Tuesday. Then I have back-to-back depositions next week, so that would be an inconvenience. I could probably delegate it to someone.
All right, thank you.
Okay.
counsel discusses there being various tests, and that's not what we're advocating. We're advocating that this court apply one test. That's the plain language rule to this statute. A statute that, on its face, does not require notice be given to a municipality before filing a lawsuit against an employee of that municipality. One of the reasons I brought up the public policy issue that Justice Beyer and Justice Johnson discussed in the O'Brien and Fernandez cases is because just as counsel has brought up and discussed in the King case, the King court stated, quote, "We must concede a strict interpretation of KSA 12-105BD supports the trial court's conclusion the notice of claim requirement applies only to claims against a municipality and not municipal employees, period. The statute is silent with regard to claims which could give rise to an action against municipal employees under the KTCA, period," end quote. Then the King court went on and talked about 5 factors which feature prominently in counsel's briefing. Those 5 factors are public policy issues. Those are 5 factors that this court and the King court should not have delved into. Those are strictly public policy issues. Does the municipality have the opportunity to investigate? Is there some type of agreement of paying of attorney's fees, et cetera, et cetera? Those are public policy issues. And it's not for this court or the Court of Appeals to engage in public policy rationale for interpreting a statute which the King court itself said is silent with regard to claims which give rise to an action against municipal employees. So the test that we want, we're not talking about, he said case by case. We're not talking about case by case. This is a plain language interpretation of a statute that we don't believe is ambiguous. The first sentence states, "Any person having a claim against a municipality which could give rise to an action brought under the Kansas Tort Claims Act shall file a written notice as provided in this subsection before commencing such action." Period. Such action is the action against the municipality.
Counsel, before you sit down
Yes.
on this particular issue, can you directly address for us opposing counsel's argument that, well, there are these other provisions in the statute about no action, et cetera,
Yes.
which cloud the issue, and then he says, since it's now ambiguous, we should interpret the statute in favor of his client? I just want to make sure you touch on those
okay,
before you sit down.
First of all, I don't believe it's ambiguous because he touched on the sentence that states, "Once notice of the claim is filed, no action shall be commenced until after the claimant has received notice from the municipality that it has denied the claim or until 120 days has passed following the filing of the notice of claim, whichever occurs first." You have to read the statute as a whole. The first sentence says you have to file it before commencing such action. The such action is an action against a municipality. It's clear in the first sentence. The sentence that he quotes, "Once notice of the claim is filed, no action shall be commenced," clearly refers to the action referenced in the first sentence. The action against the municipality. They don't have to say it twice in this statute. So I don't believe it's ambiguous. And certainly, if you do find it's ambiguous, how can this be interpreted even if you're going to go through a statutory construction when you read the entire statute together? That municipality includes employees of municipalities. It's just not there. So I'm not sure if I'm answering your question, Your Honor, but first of all, I don't think it's ambiguous. And if it is ambiguous, I don't think there's anything about the reading of the entire statute that should lead one to conclude that the legislature meant municipality, or meant any claim against a municipality or any employees of municipalities. I don't think you can get there. And especially when you go then to the next sentence, no person may initiate an action against a municipality unless the claim has been denied in whole or in part. It's really sort of repeating what it just said in the next previous sentence, but this time it includes the language municipality. So I don't think there can be any doubt that, again, using the plain language interpretation, that the legislature never intended to include employees. And I think to do otherwise and to follow the King's Court's public policy discussions would be running afoul of what this court cannot do, and that is give deference to the legislature. It's interesting that the two Court of Appeals cases that this court would have to overrule, King and Norp, both agree that a strict interpretation, which in my mind, strict interpretation means plain language. In King, they said a strict interpretation supports the trial court's conclusion that the notice of claim requirement applies only to claims against a municipality and not municipal employees. And then we go to the Norp decision, which simply followed King. And in Norp, at page 513, the Court of Appeals states, quote, on its face, KSA 12-105BD only applies to municipalities and says nothing about having application to the employees of the municipality. Despite this fact, we held in King, et cetera, et cetera. So it's interesting that the two Court of Appeals panels that looked at this both concluded that the plain language does not require notice before filing a lawsuit against a municipal employee. But King, for public policy reasons, decided to go further and enlarge the statute. So we believe that this is a very clear and obvious situation. One point, we did file a notice of claim. We are not bound by that, and we're not stopped. That was strictly prophylactic, as the court has indicated. And quite frankly, if this court rules as we hope it does, then essentially that's a null and void notice because it was not required before suing Defendant Sharp, an employee, now former employee of the municipality. So I don't think he was arguing that we're stopped. I think he was just arguing that we said one thing in the notice of claim and now we're saying something else. But I don't think that that's something that's an estoppel. That's simply, it's either null and void because the statute doesn't require it or not. Finally, Your Honors, as I indicated early in the argument, or in the rebuttal, this is not a piecemeal case at a time issue. That's why I responded to Justice Biles that I don't think you have to reach the second argument about the municipality not being responsible for or liable for the conduct of its healthcare provider employee. We simply believe that applying the plain language test, that this court should conclude that 12-105B, subparagraph D, does not require compliance with its requirements as a prerequisite to filing a cause of action against defendant Sharp, or for that matter, any municipal employee or former employee, and that this court should reverse the Court of Appeals decision and the district court decision and send this case back for trial on its merits. Thank you.
If we agree with you and the statute does not apply, then the tolling provision does not apply either, does it?
That is correct.
Right. Thank
That
you.
is correct.
Any further questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. The court will take this matter under advisement.